Hello, everyone. We will be talking about drafting responses to USPTO office actions through the help of ChatGPT. Now, before we go on to do that, it's imperative for us to understand as to uh, what do we really mean by office actions. When you file a trademark application in the US, you are going to be receiving a certain objection report from the USPTO, which will be detailing out any kind of grounds that USPTO thinks on the basis of which your trademark should be rejected or your trademark should not move ahead and get a registration. So they send a set of pointers on which you are supposed to reply and send it to the USPTO so that they can consider whether your application should be proceeding ahead for registration or not. Okay. Now, let me just share my screen and take you through one such, objection report that was sent by the USPTO. So this is how an objection report looks like, and this will be received by the applicant or their representative via email. And this objection report will contain grounds such as, USPTO would state that your trademark is very generic in nature, which means that there is nothing unique about it. Or they will state that it's very descriptive in nature, which will mean that you will outrightly be describing the um, the nature of your goods or services. For example, if you're selling cars, you keep your trademark as fast or fast cars, something like that, which will be very, again, descriptive in nature. Then third and a very important ground that USPTO would be imposing is likelihood of confusion, which means that USPTO feels that your trademark is similar to an already either registered trademark or already, a trademark which has already been filed, in front of the USPTO before you. So if that is the case, that mark will have priority over your mark. And that is why USPTO is going to be posing certain objections with respect to it when they feel that there is a likelihood of confusion, means that because of the fact that there is similarity of the overall goods or services, um, and the trademark, there is a likelihood of confusion, and therefore they are not willing to register your trademark, since you are the one who is subsequently registering, trying to register the trademark, and there is somebody who already exists who has filed an application, right? So now let's see how we can use ChatGPT uh, to basically draft such a response. Usually, drafting such a response would take uh, at least 4 to 5 hours. But taking help from Chat GPT can definitely bring down the time to, I would say, 2 hours. Um, at max, you can definitely do your research and then draft a full-fledged response with the help of Chat GPT, in a considerably lesser time. Now, let's go to Chat GPT and see how I used it to draft the response. What sort of assistance did USPTO provide me? So what I did was I had just, asked USPTO that there is this case, my client's trademark is Vaquita Dolphin, and I have received a trademark office action, USPTO office action from them. And basically, I also pasted the whole office action, which I was just showing on the screen. I pasted it over here on Chat GPT and asked for Chat GPT to send me a response. So this is the response that I had pasted, and this is the um, draft that I received in the very first go. This is the draft that I received from ChatGPT. So they have provided it to me in the form of a letter, which is the right way to do it. It is basically a letter which you're sending to the USPTO. And they have begun it, by stating that, okay, we have received this non-final office action from you, and over here we are responding to the same. They have what ChatGPT has done wonderfully is that it has divided the argument that I want to put forth into categories. Firstly, comparison of the marks, and secondly, comparison of the goods. Now, anybody who's aware of trademarks, they would agree that this is how you have to compare two trademarks on the basis of comparison of the marks itself, and then on the basis of comparison of the goods. Both of these things are to be seen when you are looking at any kind of trademark, or if you're comparing it with some other trademark. These are the things which can cause confusion, right? So you have to basically see both of these things. In comparison of marks, firstly, uh, it has stated similarity in its entirety. So it is over here talking about the fact that in its complete entirety, how uh, dolphin is very different. D dolphin is very different from Vaquita dolphin. D dolphin is our is the name of the trademark which the USPTO has cited, right? So they are saying that overall impression is different. Then distinctiveness of Vaquita, it is talking about the fact that an additional word has been added to the trademark, which is Vaquita, which brings a lot of distinctiveness to the trademark, right? Consumer perception, again, the fact that there is overall dissimilarity between how these two trademarks look, how these two trademarks are pronounced. Because of all of this, the perception that consumers will get after either listening to these words or looking at these words, it will be very different, right? D dolphin and Vaquita dolphin is very different. Vaquita is a kind of dolphin, right? So that's that. Then in design elements, it has not given a good point over here. It has stated, if we read it, it states the addition of the design element in the registrant's mark does not significantly alter the overall commercial impression, as the shared term dolphin remains a dominant feature. So if we look at it, it is in a way saying that dolphin is the prominent feature of both the trademarks, and therefore um, it is both these trademarks are indeed very similar to each other, because dolphin is a prominent feature. So this is going against us. We have to convince the USPTO that both the trademarks are different and not similar, right? So we have to do something about this point. Now, the second point is comparison of the goods. So they have firstly compared the two trademarks. Then we are talking about comparison of the goods themselves, right? Because a trademark will always be sold in respect of certain goods or services. And when we are comparing two trademarks, we have to always take into consideration both of these things, goods as well as services. Okay. So goods description, it is talking about the fact that both the description of the goods of both the trademarks is different. Both of these trademarks have been filed for in class 3, right? Class 3 would contain a lot of different goods, but the class 3 goods which we are trying to register our trademark in, and the class 3 goods which the which the cited mark is being used with respect to, both of them are very different. So over here we have stated, while both applications involve various products, a closer examination reveals distinction in nature, purpose, and consumer channels. Our goods such as perfumes, colognes, and scented candles cater to personal care and aesthetics, while the registrant's goods are centered around cleaning and sanitary products for commercial and public washrooms. This is what is has been stated over here. Trade channels. Trade channels is another very important element which one has to consider. Trade channels means where exactly are you selling your products? What are the counter on which kind of shops are you selling your products in? Are the two products going to be sold in the same kind of settings? Are both the products going to be sold in let's say, a grocery store? Or are both the products going to be sold in car showrooms? So like this, you have to consider that. Now, the difference between our trademark and the cited mark is that our products are specifically to be applied on oneself. They are more of cosmetic products in comparison to the cited trademark, which are sanitary products and are to be used in washrooms, right? So things like toilet cleaners and so on and so forth. This is what the trademark of basically the cited trademark is about, right? So there is a clear difference, and there will be therefore a difference in trade channels as well, because in trade channels there is I mean, if we talk about cosmetics, it might be sold in beauty care shops and salons and so on, whereas sanitary products and toilet products will be sold in specific grocery stores or any kind of shops primarily for such products. So there is going to be a difference in trade channels as well. With respect to evidence of third party usage, this again point is not very useful. They are only over here talking about that entities commonly produce various bath, body, and cosmetic products under different marks, supporting the coexistence of similar terms in marketplace. So in a way, they are again saying that the marks are similar. They are saying that that even though the marks are similar, there is a history that such trademarks coexist, which is again not a very strong point in our favor. Okay, and then it has concluded it all right. I mean, that all is completely fine again. So over here we have a basic structure which we can use. In fact, I would say we have more than a basic structure. We have the specific pointers as well, which can guide us to further enhance it, right? Now, what are the suggestions that we can make? So once I received this from ChatGPT, I was happy with it because I knew that I had something that I can now work on as per this. So I suggested some changes um, uh, to ChatGPT. These changes are as follows. Firstly, I said that amend the goods in class 3. So we know both of them are class 3, and like I discussed that, one is body care products, the other is sanitary. So over here, all of this is what our client is already protecting: perfume, cologne, and so on and so forth. There is one thing that I added to it, which is all of the aforementioned for use in relation to personal consumption. So this is something which I have added over here specifically. Okay, this brings out more distinction, that I am specifying that all of my products are going to be used in relation to personal consumption only, and not for using it, in toilets or other such purposes. Then, to the point similarity in entirety, I added these things, basically a case law I suggested to be added. Remember, do not use ChatGPT for your legal research. It may not come up with efficient results. And so research is something that you should do yourself. Looking for case laws is something that you should be doing yourself. And it is a good practice to include responses, case laws in such responses. So that is why I have added certain case laws. So I have stated that in similarity or in entirety point, add this case law, which specifies that when comparing the marks, all relevant facts pertaining to the appearance, sound, and connotation must be considered before similarity as to one or more of those factors may be sufficient to support a finding that the marks are similar or dissimilar. So again, the marks are to be considered in its entirety. That is what this case law is saying, right? Then content of the point titled design element to be replaced. So the design element pointer did not contain very useful information. It in fact, in a way, stated that the marks are similar, right? So over here, what I have stated is that replace what you have written with this. Applicant's unique and distinctive mark, Vaquita dolphin, is visually dissimilar to the ornate composite mark, D dolphin, in multiple ways. It is clear to see that the cited mark and applicant's mark differ because of the applicant's mark, because of the fact that the applicant marks contains two words, specific words, vaquita and dolphin. And then D dolphin is something which is like D is just a letter, and then we have dolphin, right? So this is something that I have provided over here, and I have also backed it up with a case law. Under the heading comparison of the marks, please add a fifth point titled sound, wherein we will be talking about how both the trademarks are going to be pronounced differently as well, which is again a very prominent ground that you can take, because a lot of times people will be verbally talking about a trademark or a brand, and in that case, you know um, having distinction, D dolphin and Vaquita dolphin sound very, very dissimilar to each other. So you can use it to your benefit, and you can basically provide a specific point that, both of these trademarks sound differently. Again, I have provided a case law to back that up. To the point titled goods description, please add the following: the fact that the cited mark expressly disclaims that all of its goods are specifically for use in relation to commercial and public washrooms. So the cited trademarks description specifies this, that all their goods are to be used in relation to commercial and public washrooms. This is again a differentiating factor. So I have gotten this added. Then with respect to trade channels, this is to be added if the goods in question are not related or marketed in such a way that they would be encountered by the same persons in situations that would create the incorrect assumption that they originate from the same sources, then even if the marks are identical, confusion may not be likely. So it is saying that if the trade channels are different, and even if the trademarks are identical, which means exactly the same, even then there is very less scope of confusion. And this is going to be all the more useful for us because our trademarks are also different and our channels are also different. That is why this is a good point to be brought across. And I have again backed it up with a case law. Then my final comment is, please remove the point title evidence of third party usage, which I was like just talking about it, that it's not a very useful point. Again, it is not really going in our favor. It is again in a way implying that the marks are somewhat similar. So this is also to be removed. These are all the suggestions that I gave to ChatGPT, and this is the final result that we have in front of us. It is starting from here. Again, in the format of a letter, specific details which you can fill out, Tawny details, applicants details, cited mark details with respect to that, all of that. And then, you begin with, firstly, the fact that there is a what do we say, amendment which we are going to suggest. So which was the first point that I had suggested, that we propose amendment to class 3, and we would like this to be added. Aforementioned for use in relation to personal consumption should be added. So that it has added. Then it has added the case law with respect to similarity and entirety. With respect to design element, it has replaced whatever it had stated with this explanation, and has backed it up with a certain case law. It has added the whole sound ground, which is again a very important ground and can help us to bring out the dissimilarities between the marks. With respect to comparison of the marks, there are two grounds: goods, the description of the goods, and trade channels. Again, to the goods description, it is as is whatever had been stated by ChatGPT. It did not require any change. For trade channels, I have gotten added another case law which is going to support what I'm saying. And the third point I have gotten removed because it was not useful. And then I have stated that, okay, this is how, I mean, ChatGPT itself had stated I have not made any change to it because it was completely fine. And so it has concluded it. And this is how this has been done. Now, if you are to, draft a response, this is basically a full-fledged response. You can copy it and put it in a document, and then you can upload it on USPTO's platform, or you can just simply go to USPTO's website, and then there are specific columns also which are available once you log in, and you can just fill into those columns all your grounds that you are taking, and that will do your work. So using ChatGPT will definitely make this easier. But of course, with respect, as far as case laws are concerned, that is a research that, you would have to do. Trademark practitioners, would have specific case laws with them, which can be used. So, because a lot of the responses will be with respect to comparison of trademarks, likelihood of confusion or distinctiveness or genericness, all of that. So we would have separate case laws which can all the time be used. So if you have case laws at hand, this will be a task which can easily be done within 1 hour. Otherwise, drafting something end to end and taking care of everything, being grammatically precise, no spelling mistakes should be there. All of that is something that you don't need to be worrying about. ChatGPT also gave us a basic, a very good format which we followed and through which we could cull out this whole response. So yes, this is how you can use ChatGPT to draft a response. I hope this was helpful. Thank you.